Hi, good evening, everyone. Welcome to today's talk. My name is Iyas, and today we'll be talking about this topic of which I've titled it as Intervention and Impeachment Beyond Badiaddin. Basically, what we're going to be looking at is how to set aside court orders by way of impeachment proceedings. So this isn't the kind of impeachment that we normally or commonly associate with the removal of a president. No, this is impeachment for the purposes of setting aside court orders which have been obtained through invalid means. And just to give you an outline, so we'll go through a quick run up through the general rule relating to court orders, and then we'll get into the principle of how to set aside the court orders, and then we'll look at some cases which have over the years applied this case Badiaddin, which basically sets out the role of impeachment proceedings. So in general, an order will be deemed valid unless it is set aside. So even if it is made in a questionable manner, it would still be deemed valid, and it would still be something which parties would have to adhere to. This was set out very nicely, I think, in the case of Anju Steel Federal Court, where essentially here the fundamental principle involved is that the sanctity of the court order must be observed by the parties at all time. And so it is always important that as members of the public that we have a sense of adherence towards orders by the judiciary. And the judiciary only really gets its strength from public confidence. And so there is no public confidence in the adherent at the validity of court orders, and this is something which can in fact affect the administration of justice. But the courts have also realized that sometimes they make mistakes and they give court orders under wrong circumstances. And that means that they have now designed this process in order to sort of correct these possible mistakes. And this was basically the main point in this case of Badiaddin, which essentially this was a case where an order for sale of a piece of property was actually, in fact, granted, despite the fact that it was in against statutes relating to the Malay Reserve Land. And here the courts realized that the order has to be set aside. And they basically gathered that it will be set aside under situations where this particular order was granted in excess of jurisdiction or for the grounds of illegality. So here in His Lordship, Justice Muhammad Azmi, he basically said that one special exception to the rule that orders are final and they must be adhered to is that if the order could be proved to be null and void on the grounds of illegality or lack of jurisdiction. And essentially what it means is that if a person is affected by this order, they are then entitled to apply to have it set aside by use of the court's inherent jurisdiction to correct and fix their inherent, to fix any kind of irregularities. And basically, Badiaddin took the cue from this other federal court case of EU Finance in the year 1982. Badiaddin affirmed this case. And essentially, it sets out that if you want to set aside a court order that was obtained through an invalid way, then it can be, and I quote here, successfully attacked in collateral proceedings. And then through the collateral proceedings, you impeach that order. And it is through the full successful impeachment will the court determine that this order is to be set aside. So that was the principle that was affirmed in EU Finance and also affirmed in Badiaddin much later. However, this isn't a catch-all. This isn't like a free-for-all where you can take any court order and question it under any circumstances. There are limitations to this because this is actually a very expansive use of the court's inherent jurisdiction. And here, Badiaddin once again makes that caveat and says that the contravention has to defy a substantive statutory prohibition so as to render the defective order null and void on the grounds of illegality or lack of jurisdiction. So it shouldn't be applied to correct certain very small procedural requirements. And generally, it has to be invoked in very, very exceptional cases. So, like I said, there are limitations to this, and it isn't something which it isn't something which one can readily use under any circumstances. Now, there have been a few cases over the years applying this test, applying this rule in Badiaddin. And what we'll do is we'll go through these cases to see how it's been applied. So generally, the principle still stands. If there is a court order that is irregular, it was invalidly made, it was perhaps granted in excess of its jurisdiction, then the only way to either question it will be two ways. One would be to appeal, and the other one would be to impeach under the Badiaddin principle. However, in 2000, the Court of Appeal had, in fact, in the case of Selvum Holdings, in applying the case of Badiaddin, they explained that Badiaddin set down two circumstances where the earlier order had contravened a substantive statutory prohibitions, just like I said previously, and only in exceptional cases where justice requires the court to intervene and correct that earlier order. And here is the biggest takeaway from Selvum, in my opinion, that here Justice Siti Norma held that, and I quote, "expressed in another way, there is no need to adopt the appeal procedure nor to file a fresh suit to set aside the defective order. This can be done in the same proceedings where the impeached order was granted before the same judge or another judge with concurrent jurisdiction." Concurrent jurisdiction meaning a court of similar, who is placed in the same hierarchy. But here is the interesting point here that basically Justice Siti Norma explained that there is a way to go about in impeaching an order and setting and having it set aside. And this is not just done by the appeal procedure or to file a fresh suit that Badiaddin had explained. So this particular case, what we can see as it has potentially expanded the routes which a potential litigant could take in order to try to set aside these court orders. Now, this potentially conflicts with another federal court case of Hong Leong Bank Bhd and Steichhorn. Essentially, this particular case was an issue relating to an intervention with the purpose to try and intervene into proceedings and to submit. So, but essentially, here the federal court held that when an order has already been determined, then and once all parties have submitted, then that's final, that's perfected, and a judge cannot reopen this case unless you take it up on appeal. And then secondly, the application for leave to intervene, because this was a case relating to the issue of intervention, must be made under this order, Order 15 Rule 6, but can also be done at any stage of the proceedings. And this any stage of the proceedings quote here was taken directly from this particular rule under Order 15 Rule 6 of the Rules Court. So what the federal court had interpreted this phrase "at any stage of the proceedings" as meant that this has to be before judgment. And the reason for this was as founded by the federal court. Otherwise, the proceedings that have concluded because if you had not applied before judgment, it means that this was something that was contrary to this particular quote. The quote meaning that any stage of the proceedings means that it has to be during live proceedings. It does so as soon as the order has been given, has been directed, has been perfected and sealed, then there is no longer any proceedings in existence, and there is no proceedings for this party to intervene in. So this particularly conflicts because previously Selvum held that there was an order, it was already granted, it was already perfected and sealed, and yet someone can still come in, intervene, and have it set aside. So there are these two conflicting decisions. However, this was something that was addressed in the federal court once again in 2013, in the case of Arab Malaysian Finance Bhd. And essentially, the federal court here realized that there was this potential conflict and went on to analyze the two cases, Selvum and also Staghorn, and found that in relation to the finding in Selvum, basically it involved having to re-examine the whole principle under Badiaddin. And here the federal court found that after careful re-examination, that there was no way that the court found that the court's inherent jurisdiction could extend and correct an earlier regular judgment other than the judgment which has been granted in contravention of a statute. So once again, it goes back to limiting the scope of how you can go on to impeach and set aside this court order. Sarah further goes on to say that Badiaddin reaffirms the rule, and also goes on to say that the point in Selvum should not be interpreted as giving the courts a broad power to set aside a previous perfected order under the guise of exceptional cases. So taking the phrase to intervene and correct the serious defect in the order, Sarah explains that it should, and I quote here, be read in the context of where an order was obtained in a manner which contravened the statute, resulting in that order being illegal made outside the jurisdiction. So in this respect, the court's inherent jurisdiction may be exercised to strike out that earlier order. So what we found was that the cases of Selvum and Staghorn were in conflict as to how one could potentially mount a challenge in order to set aside this particular a court order that is being questioned. And the federal court had to step in to clarify the matter, to say that Badiaddin only really applies very limited circumstances, and it can only be done through the filing of a fresh action to impeach, as opposed to applying to intervene into the proceedings itself in order to have that set aside. These three cases were essentially canvassed quite extensively in this recent decision of this recent case of Datuk Syed Hamzah and Pendaftar Suruhanjaya Syarikat Malaysia. This was a case which our firm and myself had worked on quite extensively, and essentially the background of the facts involved here the appellant was a former director of some of these companies, which he wanted to correct the share members registry because he believed that the share members registry was incorrect and that there was some issues with it. So he tried to apply to SSM in order to rectify it under Section 602 of the Companies Act. However, here the first respondent, which was SSM, had dismissed that first application on the basis that they didn't have the power to handle the case, and this wasn't something which was an error in the course of their duties within the meaning of Section 602. And so here the appellant had applied to the High Court to appeal against that decision. And so the High Court had then ordered that that particular application be reconsidered by the first respondent, by SSM. However, in this particular case, one of the companies that were affected had applied to intervene in order to set aside the High Court order, and did so, that company did so on the basis of the principle under Selvum. At first, the High Court allowed the intervention, set aside the first order, and ordered for a complete and total rehearing. And so the appellant appealed to the Court of Appeal on this. And the Court of Appeal found, after canvassing all these three cases of Selvum, Staghorn, Badiaddin, and also Serak, so these four cases, after canvassing this, it found that the original High Court order to reconsider the application is to be reinstated. That's number one. And then number two, the court at the time was functus officio. No pending proceedings for the intervener to intervene into, so upholding the case in Staghorn. But also by way of an observation that any interested party was at liberty to apply by way of a separate action to impeach the order. So it once again goes back to reaffirming Staghorn, and then also to reaffirm the case of Serak as well, and also to slightly distinguish itself, or if not, depart away from the principle held in Selvum. However, the story doesn't end there, because there is another very recent federal court case here of Dr. Lourdes Davaraj. One of the issues that were canvassed here, where essentially it was about one of the parties here was subject to disciplinary proceedings. However, another party came in and tried to judicially review the disciplinary proceedings that were held by the Malaysian Medical Association. And so that fight happened all the way up to the High Court and then to the Court of Appeal. However, it was only at the Court of Appeal level that the person in question that was being subject to disciplinary proceedings had actually gotten notice that this whole thing was happening, because he didn't know that this thing was happening to him, and so applied to intervene. The Court of Appeal found that they should have followed Staghorn, and there was no proceeding to intervene into, because that High Court decision was already over. However, the federal court here found that under this particular circumstance, Staghorn should not apply, and found that this was one of those cases where the intervention was necessitated because of a serious miscarriage of justice arising as a consequence of a breach of natural justice. Breach of natural justice meaning that because the main doctor subjected to disciplinary proceedings was not even heard at the judicial review stage, was not given the opportunity to present his case, was not given the opportunity to submit. And because of that point, that was a substantial breach of natural justice, which allowed, which the federal court found that this was something which warrants an intervention, warrants this party to come in to apply to intervene and also to set aside the order. So we're back on shaky grounds here. We had a situation where the case of Selvum says you don't need to file an impeachment proceeding. You don't need to appeal. You can just intervene and have it set aside in that same proceeding. And then this was rectified again by Serak, which Serak says that you should still go back to the status quo that was held in Mahidin. But now we're back to this case of Dr. Lourdes, where there is this extension or potential extension that one can intervene in and have a court order set aside because it's a breach of natural justice. So to conclude, so just to summarize and recap what we've just spoken about, that you want to set aside a court order, you do it by way of an appeal or by way of separate impeachment proceedings. You file a fresh suit to attack that particular order, say that what it needs to be said, whether it falls under the grounds held in Badiaddin. That's number one. Then number two, that impeachment will only be granted if, and these are the two categories that Badiaddin expressly stated, which is an access to jurisdiction or made in breach of a statute. But now with Dr. Lourdes, there might be an expansion of this to account for this breach of natural justice as a new ground for which this impeachment may take place in. So that is essentially what we have to just bear in mind. If you do want to, if you do have a court order which does raise a few serious questions, then it is something which you might consider filing a fresh suit against to impeach. This will mean that you will need to essentially go through a full trial to essentially question every single matter or every single conduct or every single point that was canvassed in the original proceedings. And you do this by way of trial. And then at the end of that, the judge will make that finding to say whether this was something that warrants setting aside or is something that should be dismissed. And that is pretty much it. If you do have any questions, I'll be happy to take them. Or else these are my information, so you can email me, or that's the firm's phone number. So if there's anything that you would like to say, or if there are any questions that you have, I'll be happy to take them. Okay. If there are no questions, then you can always just email me. I'll be happy to hear you out. All right. Thank you very much. Have a good night. Stay safe and hope everyone stays healthy. And lastly, happy 2021. Thank you.